Martin Borowski.
Nice to meet you. ¿Tienen otro papelito de esos para tomar notas?
Toma nota.
No me, ya no alcanza.
No te preocupes.
No, no, sí.
Este es.
Este es mío.
No, tampoco es mío ese.
¿Y este de quién es?
Hast du das gekauft?
Ja.
Ah, mein Gott, so
Ja,
alt. Total kaputt.
Good morning, buenos días. Tenemos de invitado al profesor Martin Borowski de la Universidad de Heidelberg. La conferencia será dictada en inglés y los comentarios también los haríamos en principio en inglés. I will shift to English soon. Entonces, nada más como para ponerlos en contexto, cualquiera que quisiera hacer un comentario, alguna pregunta, puede hacerla en español y los demás ayudamos a traducirla en inglés en dado caso, si por alguna razón el idioma sienten que no da. Hay todavía mucho lugar en la mesa, los invitaría a que se sumaran a la mesa, de los que están en las laterales, si pueden. Entonces ya tenemos mucho espacio. Más o menos la mecánica sería dejarlo exponer a él primero unos 40 minutos, 30, 40 minutos, 30, 40 minutes, ¿ok? For you to present? Short. Okay.
50.
20, perfect. Entonces, me aclaran que él más bien hablaría 15 a 20 y los demás...
Nobody said it to me. Sorry.
Wir haben viel Zeit.
Okay.
So,
I take a bit longer.
Ok.
yes.
Entonces,
I was assuming that over
No, there was a
okay.
miscommunication.
Okay.
I'm sorry about that.
ok, un poquito más de... Yes, perfecto. Entonces, bueno, hablará primero Martin, no limito los tiempos. You will speak for as long as you want or you have to take.
It's dangerous.
I know. Saying this to lawyers and to philosophers is very dangerous.
Yeah.
And to the combination is especially explosive. Bueno, obviamente, entonces, pero bueno, a ver, va de nuevo. Entonces, primero hablaría Martin Borowski y luego hablaríamos los de la mesa. Yo creo que le daría primero la palabra a Mariana, a Alejandro, luego a Faviola y luego cerraría yo con algún comentario, alguna pregunta para Martin y ya le daremos todo el espacio al que contestar algo y abrimos la mesa para el público, comentarios, preguntas. Insisto en que si alguien quiere hacer una pregunta, que el idioma no sea la limitante, con mucho gusto tratamos de hacer la traducción o lo que haga falta. So, the idea is that you will be speaking first, so don't take too long. Wherever you need, but don't take it too long. And then Mariana, Alejandro, Faviola, and myself will do some comments on your exposition on the paper, and you'll have a chance to reply, to comment something, and then we'll open the floor to the general public to see what they have in. But let me also welcome you to the Institute. I know you have been already in a previous event today, but I'm very glad to have you here. It's always nice to have good friends from all over the world visiting the Institute and also visiting Mexico, so I'm glad you're here. And I know Arnulfo is taking good care of you, so that's also very good.
He does.
But I think that's pretty much for us a way of introduction. But we'll be speaking on John Rawls and the religious freedom, and then we'll all interact. So you have the floor is yours.
Thank you very much. I'm grateful for the invitation by Dr. Imer Flores to present here at UNAM an outline of an essay on John Rawls' conception of religious liberty. Actually, technically, he would say liberty of conscience, because conscience is very broad for him. I came across Rawls' theory when I was writing my second dissertation, that is the habilitation, as a requirement to become a German law professor. You have to have this habilitation, and it's basically a dissertation, but 2 or 3 times as big and as long. So a monster dissertation, you could say. And I was dealing first and foremost with the doctrinal constitutional law of Germany, the German constitutional right. But of course, you want to have that rounded up also towards political philosophy. And I chose at that time, this is about 15 years ago, that I published my thesis. At that time, Rawls struck me as a good case to use as an illustration what is done in political philosophy in the name of religious freedom. Now, Rawls is not the most recent theory. It is a theory that is basically 50 years old, but I think it is a modern classic, and it has influenced the debate on political philosophy and human rights afterwards significantly. There are more modern approaches, James Griffin, for example, or other approaches could be mentioned here, but Rawls is still, I think, good to look at and to discuss. Rawls' theory of justice, I would say, has two parts or two periods. The first period is his classic theory of justice in the liberal democracy. And the writings here are his A Theory of Justice and Political Liberalism, 1993. This is one part of his theory, I think the more important one. The second part is then characterized by his small book, 1999, The Law of Peoples, where he extends his theory from the democratic constitutional state to public international law by kind of trying to use the same theoretical devices. I'm not particularly optimistic that this is a good strategy. I'm more keen on his original theory, and I think this will be difficult to hide in what I'm mentioning here. So in his first part, Justice as Fairness, Rawls proposes a political conception of justice for a state. Now, a crucial part of his theory is the fact of reasonable pluralism, and he assumes that citizens hold what he calls comprehensive religious, philosophical, and moral doctrines. This is basically the idea of a good life, with all the moral values that accompany that. And now there is pluralism. So there is no homogeneity. A state is not characterized by actually all citizens having the same idea of a good life, but actually a different comprehensive doctrines. And this, he insists, is an enduring attribute of modern democracies. So this is not something that, like an untidy desk, happens, so to speak, by itself, but it is something for that there are normative reasons. And then he has two technical main elements in his this first period of theory. Probably the most discussed element is the original position. This is a hypothetical situation in which persons decide on the principles of justice. Now, this original position is characterized by certain side constraints. This is, for example, the veil of ignorance. So we don't know in this original position which place in life we later will have. And this is so that everyone basically stays neutral. Mm-hmm. And he also employs assumptions such as the maximin rule, that everyone is a bit pessimistic and tries to maximize the worst outcome in society. So not gamblers looking for to be a pirate, the most successful pirate of the Caribbean or something like that, but one assumes with some modest pessimism that things tend to go wrong and that you maximize the situation when life is not very friendly to you. Now, this theoretical device, of course, well, this is a bit, let me say, this is the white rabbit problem. The principles of justice from Rawls, they are the result of the original position, because the result, the rabbit, is basically put into the cylinder. It is put into the cylinder by the characterization of the original position, and all the rules that apply to the information that people have, the rules under which they decide, all these imply then that certain principles of justice result, and this is because Rawls designed them so. So this, seen as such, is a weakness, and he tries to counter this weakness by a second device. This is the reflective equilibrium, and this is basically presupposing that we have a sense of justice, and that the sense of justice basically is a proper guidance for us. And sometimes we are in error, sometimes we are ideologically influenced so that we don't see the proper way to justice, but at least there is something valuable to that, and there needs to be coherence between the principles as they actually result from this original position and our well-considered judgments on deciding everyday cases in applying basically what are these concretized principles. In political liberalism, he adds the idea of the overlapping consensus. This refers to these comprehensive doctrines. And his idea is with these comprehensive doctrines that we have different, not everyone has one own, but we have different groups of comprehensive doctrines that are competing in some areas with each other, and that there is then a political conception that actually permits us how we can reconcile these conflicting comprehensive doctrines. So how can actually someone who decides to become a monk and to devote his life to Christianity, and how can someone who decides that the way for him to go is to become a stock exchange broker and make its money? How can we reconcile the competing demands of these people from a state and a framework that the state sets? How can we reconcile that? And for that we need a political doctrine that ideally, that is his point, actually emerges as a kind of area where all these comprehensive doctrines meet. He insists, and this is the important point, he insists on that this political conception is not a comprehensive doctrine. It is something different. It is freestanding in his view. Okay. Good. Then the results of this original position are his principles of justice. The first is dealing with liberty. Each person has an equal claim to a fully adequate scheme of equal basic rights and liberties, which scheme is compatible with the same scheme for all. This is basically a Kantian idea. And in this scheme, the equal political liberties and only those liberties are to be guaranteed their fair value. The second principle is social and economic inequalities. It's about now the redistribution of wealth. Social and economic inequalities are to satisfy two conditions. First, they are to be attached to positions and offices open to all under conditions of fair equality and opportunity. And second, they are to be to the greatest benefit of the least advantaged members of society. The latter part is the difference principle, which has been much discussed. I'm not going to talk about this today here. Important is, however, for Rawls, there is a lexical ordering of the first principle over the second, which means liberty always takes absolute priority over the redistribution of wealth. Absolute priority. In particular, no balancing. Now, you realize a skeptical tone here. Good. Rawls is aware that these two principles are, of course, very, very abstract, and that you cannot apply them to individual cases. These principles require concretization, and interestingly, concretization in 4 stages. The first stage for him is the original position, where the principles are chosen. Now, the second stage of concretization is the Constitution, when actually the constitutional framers record the Constitution and then decide the issues of liberty and redistribution of wealth in the provisions of the Constitution. Then the third level of concretization is legislation, when the simple parliamentary majority enacts parliamentary statutes in the framework of the Constitution. And finally, the fourth level is adjudication, where in the boundaries of parliamentary statutes, the executive and the judiciary are taken decisions of individual concrete cases. Now, it's of course tempting now to put this opposite to Hans Kelsen's hierarchical structure of the legal system, but we have no time for that. But I kind of got the idea that this is something that needs to be done expressly. I need to talk since I was asked to talk not too short and not too long. I have to give a couple remarks on his second phase, the law of peoples. This is important, of course, for religious freedom, because here he introduces the concept of human rights. And human rights are for him defined as a narrow class of urgent rights, which are observed by well-ordered peoples. And that they are observed by well-ordered peoples is the background for their function. And the function is in public international law, so Rawls would have us believe here. The function is that they give legitimacy to an intervention by other peoples in public international law if one state treats his own population indecently. And indecently means for Rawls by systematic and sustained large-scale violations of human rights. So human rights become, so to speak, the precondition for an intervention on grounds of human rights. This actually has led in the more recent debate to a political conception of human rights, or we could say functional, which say, well, this is actually what human rights are. They are limits to state sovereignty, to the effect that actually they are not observed, that then actually the public, the international public is empowered to intervene. Now, in my view, this puts the cart before the horse. Charles Bates has also developed a understanding of human rights on that basis. It is, of course, an important function of human rights in public international law, no doubt about that, but this is not the only characteristic of human rights. This is one of their effects, and domestically they have important other effects. Good. Now, interestingly, if you write a habilitation of freedom of religion, interestingly, Rawls' list of basic liberties begins with freedom of thought and liberty of conscience. And he understands liberty of conscience broad so that it includes religion. And there's also political liberties, freedom of association, and freedom specified by the liberty and integrity of the person, rights and liberties covered by the rule of law, and the right to personal property, interestingly. Good. Good. Now, what is important when we look at this list is that this list is in that sense exclusive, as for these liberties just mentioned, there is priority over reasons of public good and of perfectionist values. This is to say that basic liberties, this rather short list, if you look at other catalogs of human rights, this list is closed in the sense that a limitation of one basic liberty can only done justified by another basic liberty, but not by something outside the list of basic liberties. Again, we have this idea, as we have already with the first and the second principle, of an absolute or lexical ordering. Good. What else is remarkable if we look at this conception? it is the scope of protection of various conceptions of the good. So Rawls is fairly open if it comes to these comprehensive religious, moral, and so on doctrines, that he is open to religions, basically every religion. It can be a philosophy of life, so it doesn't have to presuppose a God as a transcendent being that actually created man or something like that. It is basically everything possible here, and this is relatively broad. And here, Rawls, with this broad understanding and the fact of pluralism, Rawls explicitly refers to the historic situation, particularly in Germany, in Europe, at the end of the Reformation, when actually Reformation and Counter-Reformation had ran through Germany and left a completely scattered landscape, and there was simply the factual necessity, so religious homogeneity was ruled out by the fact that it was, so to speak, so scattered throughout the landscape. So homogeneity was not an option anymore. And then basically the fact of pluralism, the first place in time and space, at least I know properly to say that, where the fact of pluralism was realized was at the end of Reformation in Germany in the 16th century. Okay, so this is good if you want to compare this with German religious freedom. It appears that German religious freedom, at least the contemporary interpretation, is also fairly broad. Every religion, basically, that would be described by theologians or religious experts as an instance of religion is covered, and even philosophies of life, if you adhere to them, can qualify as a Weltanschauung. Philosophy of life is, so to speak, a religion without God. So this runs fairly parallel. Now, the basic standing of religious freedom, this is quite important for Rawls because he models his whole theory around these comprehensive doctrines and the protection of the conception of the good. So this is something that is very important for him. This is why he begins his list with this, and then there comes only a narrow class of urgent rights. This again is something you can see in the case law of the German Federal Constitutional Court. In Germany, you have human dignity as a constitutional right, and then more specific constitutional rights. And the German Federal Constitutional Court has repeatedly said that freedom of religion is a specific concretization of human dignity. In some sense, all constitutional rights are a concretization of human dignity, but freedom of religion and conscience is a specific concretization. So this again underscores the importance, and this echoes to some extent the central role that this plays for in Rawls' theory. Now, I agree very much with Rawls when it comes to the doctrinal details of how to deal with the limitation and concretization of human rights. The agreement tends to vanish somewhat. This begins when Rawls distinguishes between restrictions and regulations. Now, what is that? Rawls gives an example, the example of freedom of speech. Interference with the content of the speech. So if I'm not permitted to say what I want to say, this is something he considers a restriction. Whereas interference with the modalities of speech, place and time, counts merely as a regulation. And regulations, he says, do not offend against basic liberties, and this is, so to speak, they are not as problematic as restrictions. Now, I disagree on that count, I have to say, because this is a matter of degree. Because if I'm permitted to say what I want to say, but I only am allowed to say this in a specific deserted place in the desert, at 3 a.m. Sunday morning.
And no internet.
No internet, and of course you get the
No
point.
people
Yeah,
around.
exactly. So then of course this amounts basically to de facto to a limitation of content, because I'm not effectively. So this is why in the German doctrine of constitutional rights, specifically when it comes to freedom of speech, it is clear that the modalities, time and place, are protected, and they are no less protected by some kind of doctrinal distinction, and so I don't think that this is particularly convincing. And also when it comes to restrictions and regulations, strangely, one is more suspicious than the other in his view, but he doesn't distinguish with an eye to the criteria for the justification. So it is not, if you read Rawls, that regulations are easier to justify than restrictions. You get the very same set of criteria for the justification for both things. So this again, I think emphasizes that there's no point in distinguishing these two phenomena. And then with an eye to the strict priority of basic liberties over other goods or constitutional essentials, as he calls them, this is, he says explicitly, this absolute priority shall avoid balancing. Balancing, Rawls would have us believe, is often uncertain and indeterminate, and to use it would weaken the protection of the important liberties. Well, yes, no. Yeah, there's a wonderful combination of yes and no in German.
Ja, genau.
This is Alejandro mentioned it just. Well, the point is, of course, if you have absolute priority, you don't have to think much about the result because you get a result. The problem is that this result is in a significant number of cases likely to be inadequate. So the price for the certainty you have to pay is inadequacy. And this is where the problem lies. Now, Rawls he's a political philosopher, so he is forgiven of not having paid much attention to the principle of proportionality. And of course, he is an Anglo-Saxon political philosopher. And as we know that the Anglo-Saxons, particularly your neighbors north the border, are not keen on the idea of proportionality balancing, but instead have their specific tests, the rational basis tests and the compelling state interest test, which mean that you get answers quickly, but the problem is which test to employ for what reasons. But okay, so it's understandable to some extent that Rawls is critical here. I would not be critical, and I would, and you got the point I think already, I would resort to balancing without any problem whatsoever. And this, what we can have, and this is the last thing, I think this is now kind of compromise between too little and too much.
No, that sounds good.
The balancing, well, absolute priority means in all cases there's a priority established. Now, balancing does not necessarily mean that you start from the outset with the equal likelihood of one side outweighing the other. What you can introduce is something like a prima facie priority or a relative priority. That you say that, for example, freedom of speech is, for the political purposes is a particularly important constitutional right, and that it has significant weight typically in the balancing. So that often freedom of speech will win the competition, but not always. And these kind of prima facie priorities then I think offer significant practical guidance, but at the same time they do not compel us to pay the price that absolute priority asks us to pay, that is inadequate results in a significant number of cases. Thank you.
Thank you. Mariana?
Well, first of all, thank you for the invitation. I'm really glad to be here. And I also am sorry for my English, but I will try to do my best. First of all, I want to say that I'm not a political philosopher, and
I'm neither.
also not a lawyer and not Anglo-Saxon. So the point of view that I will expose here is a sociological point of view. But I think that there are a lot of matters in which we can discuss combining all these disciplines. So what I want to point here is one very specific topic, which is the comprehensive doctrines pointed out by John Rawls. I think this is really important in order to assess other issues, political issues and also social issues, because comprehensive doctrines are plural. I mean, as Professor Borowski already told, this is an attribute of contemporary political communities, democratic or not. And comprehensive doctrines are difficult to observe. They are also heterogeneous, I think. However, it is important to note that they are frameworks or a kind of framework to understand reality. So comprehensive doctrines, religious or other, I mean, political, philosophic, moral, etc., they represent a whole group or a whole integrated, ¿cómo se dice conjunto? A whole integrated system or body of beliefs, of ideas of the good or right and the wrong or bad. And they provide a kind of conceptual or a theoretical frame by which persons are able to understand and to interpret their realities. Not only their individual or personal reality, but also political and social reality. What is happening in the world? What should they do in that world? And so on. So, considering this, there has been a strong debate between exclusionism and inclusivism. By exclusionism, I mean those authors who think or defend that religious arguments should not participate by any, I mean that there's no question that religious arguments should not intervene in the public debate in order to decide the political community issues. And on the other hand, there's inclusivism. These authors defend that religious arguments should participate in the political debate since they are part of the society. And by being part of the society, they are also part of the political community. So the question here is if we need to translate religious arguments to a secular and rational approach, or we shouldn't. At least that's what I understand of this debate. But I also think that this debate is related to other issues, and these issues are sociological. For example, there is nowadays no proof that religious convictions or that any other comprehensive doctrine actually is related or expresses in a political preference. I mean, I personally think that religion, as any other comprehensive doctrine, does have an important influence on political preferences, but maybe that's not true. So what should we do? I think this is a really important issue for the research agenda, since it's possible that political pluralism is even is even deeper than religious pluralism. So I think we should discuss a bit on that point. And the other problem that I think that we should discuss here is that besides this religious and political pluralism, we also have the issue, especially in countries like Mexico, that we do not have equal conditions for participating in the political debate or in the public debate. So besides, we have an ever-growing pluralism, not only in religious matters, but also in social matters. The political system is not guaranteeing that every group and every person is able to participate actively in this public debate. So the concrete question is if we should think about this debate before thinking if a religious argument should or shouldn't be included in the public debate. I mean, what is more important? Is it more important to decide if religious arguments could or could not participate in political debate? Or do we have to resolve one thing before that? I mean, do we need to find solutions in order to guarantee that every person has the same equal opportunity of participation in their political community? I think both problems are related, and I'm sure that we won't find the answer here and now, but I think there are two problems which are interesting to discuss, and that we have a great opportunity here because we have philosophers, lawyers, sociologists, and so on. So that's it. Thank you.
Alejandro, te pasan el micrófono.
Sí, no, gracias. Thank you. Well, good afternoon, everyone. I am glad to be here today, for I was invited to talk about the Rawlsian perspective on religious freedom as a fundamental legal right. But I am also honored to be invited by my good friend and colleague, Imer Flores, one of the best legal philosophers in Latin America, to present a paper on my good old friend and colleague, Martin Borowski. We met since some years ago, right?
Too long to remember.
Yes. A paper which was translated by my new friend, Arnulfo, who, by his own initiative, decided to make the translation of some papers of Martin. I hasten to add that I know very well how hard and grateful is the work of translating. Therefore, I want to congratulate Arnulfo. And by the way, speaking of congratulating people, I want to share with all of you that today is the birthday of our great friend and colleague Imer. And therefore, you know what you should do after the event, and please don't worry about the coronavirus.
I have gel.
I will give you a Japanese
Okay.
hug.
Or elbow.
Yes, okay, that can be. The present lecture of Professor Borowski deals with religious freedom as a basic right in the democratic constitutional state. Although it is well known that John Rawls, one of the most influential political philosophers of our time, abandoned his religious perspective shortly after the end of the Second World War. We know this from the recent publication, A Brief Inquiry into the Meaning of Sin and Fate, Rawls' undergraduate senior thesis, submitted some time ago, just before he entered the army. It is a fact that religious freedom remains to be considered a basic right. For the relationship between politics, rights, and religion is at the core of the problem that liberalism has for centuries meant to solve. In fact, the moral horrors of war made it impossible for Rawls to believe in an all-knowing, almighty, all-loving, divine intelligence watching and justifying all that horror. But this didn't affect him to consider religious tolerance as paradigmatic for a just, democratical, decent society, as Richard Rorty, Daniel Dombrowski, Tom Bailey, Valentina Gentile, and many others in the recent years have argued. With that said, and with an eye to develop religious freedom as a basic right based on the Grundgesetz, Borowski outlines some of the features of Rawls' theory that are related to religious freedom, more specifically basic liberties that, according to Rawls, have priority over reasons of public good and of perfectionist values. And with this, with an aim to avoid balancing problems. Here, Borowski refers to liberty of conscience, Rawls, the liberty to choose one's religious, philosophical, and moral views. But problems arise when one thinks of basic liberties restrictions. This turns to the determination of the scope of protection of diverse conceptions of the good. Borowski rightly points out that for Rawls, religious freedom as a fundamental right has a basic standing, for it stems from the transformation of the liberty of conscience, qua basic liberty, in constitutional law. But as liberty transforms into basic rights, problems of concretization through positive law are ought to appear. For legal rights, qua rules and principles, leads to understand them as absolute or relative rights, the relative and absolute dimension of human rights. At this point, Rawls' distinction between rights and limitations on rights is useful, but insufficient to explain religious freedom as a basic right. If religious freedom is a part of Rawls' basic liberties, do they have absolute priority in every case when they are confronted with another right? This, I think, cannot be solved within Rawls' own theoretical framework. For an absolute priority given to some basic rights cannot explain not only how to solve a conflict of human rights, but his own structure as human rights. The priority of rights over collective goods, constitutional essentials, and other type of rights must mean, on the one hand, that authorities ought not to override them without adducing special reasons. On the other hand, however, it would be a mistake to think that collective goods are not an essential part of the law. In fact, rights and constitutional essentials can coexist, and where conflicts between them arise, they can be balanced in any legal system. Collective goods can yield to rights in some situations, but this requires proper analysis, taking into account the normative status of rights. As it can be seen, even if Rawls wants to avoid balancing, for it might weaken the protection of important liberties, in practical terms, this might be quite problematic because this should lead to give absolute priorities to some rights. At this point, Rawls' theory cannot be in a position to determine how to balance religious freedom against other rights, like, for example, the right to life, a moral principle and a universally recognized right based on the belief that a being has the right to live and, in particular, should not be killed by another entity. This situation can be solved by means of principles theory, which comprises the determination of the content of this freedom as a principle, that is, a relative content of the basic right, and the rational method of weighing principles, that is, balancing. At this point, Borowski states correctly that a prima facie priority, instead of an absolute priority, might be best suited to justify rationally restrictions on human rights by means of connecting, weighing, and balancing rights like freedom of expression and religious freedom. With this, religious freedom can be protected within the institutional framework of a democratic constitutional state and let people choose his own beliefs. This is certainly another reason for considering the importance of proportionality on basic rights without compromising, let alone renouncing, the basic commitments of reasonable pluralism and political liberalism. Thank you very much.
Faviola, por favor.
Thank you, Imer. First, I want to thank the invitation and apologize because of some miscommunication. I was not aware. I was supposed to be at this table. I was planning to attend the lecture, so I'm sorry, I'm not very well prepared. But there are a couple of things I will say. Well, my name is Faviola Rivera. I'm a professor at this university, and I work at the Institute of Philosophy. So I'm a philosopher. And I met John Rawls in '92 when I arrived at Harvard as a graduate student. That was a long time ago. People had been reading Rawls for 20 years at that time, and then now I remember Anthony Layden's article, which I very much recommend, from 2001, when he wrote The House That Jack Built, 30 Years of Reading Rawls. And now I realize, talking to Imer, that it's going to be 50 years of reading Rawls next year. It's going to be 50 years of A Theory of Justice, which was published in '71. And I'm very happy to hear now in Professor Borowski's talk that Rawls is considered a modern classic. So I'm very happy to be here and talking about Rawls. And I'm going to say two things. One is a clarificatory point. It's not terribly important, but I want to mention it. And it's about comprehensive, what a comprehensive doctrine is, and why Rawls introduces this concept in political liberalism. Well, it was introduced before in the articles that led to political liberalism and that appeared, that were put together there. And I mention it only because it's important for Professor Borowski's presentation. And in A Theory of Justice, of course, Rawls was very much aware of the pluralism of conceptions of the good. But he doesn't talk there about comprehensive doctrines in A Theory of Justice. He talks about a pluralism of conceptions of the good. So the very fact that Rawls considers necessary to introduce this concept later on in later articles, and particularly in political liberalism, suggests that there is an important difference between the two concepts. A conception of the good, as we, or most of us know, is a conception held by an individual about what is good in life or what makes his or her life worth living. That's the basic idea of a conception of the good, and anything can be a conception of the good. And it need not be moral. It may be highly immoral. Conceptions of the good may be highly immoral. Now, when Rawls talks about a comprehensive doctrine later on, he means by this a moral doctrine. So comprehensive doctrines are not supposed to be moral, are supposed to be moral doctrines. And the main difference between a conception of the good and a comprehensive doctrine for political liberalism is that, by contrast with conceptions of the good, comprehensive doctrines raise the stakes of justification for a theory of justice. And they do because comprehensive doctrines compete at the level of philosophy in giving a justification for principles of justice. So Rawls has to offer a justification of, he was not aware of this when he wrote A Theory of Justice. He said later, explicitly so, he was not aware of this problem. And so he has to offer a justification of the principles of justice, as Professor Borowski was reminding us, which is a political justification. I cannot go into the details here. In order to show that he can offer a justification that is acceptable to all, or to all reasonable, he says, comprehensive doctrines. The point here is that comprehensive doctrines, among which he includes religious doctrines, but not only, can also offer a justifications for principles of justice. This is not something that conceptions of the good do, not necessarily. Many conceptions of the good do not care about political justice, and they don't care about or have no resources for offering a justification for principles of justice. Think, for example, a person for whom his good or her good is around music or family life or what have you. And they don't have conceptual resources for offering a justification for principles of justice, and they don't care about it, and that's fine. But comprehensive doctrines are different in this way. They have the conceptual resources for offering different views about the justifications of principles of justice. Think of religious conceptions that can offer an account of political justice and tell us where the justification lies. And so Rawls became aware of the need of characterizing first comprehensive doctrines and addressing them, because he has to offer a kind of justification that can be an alternative to what comprehensive doctrines offer in society. So philosophy is not necessarily in an authoritative position. That's what Rawls came to realize. Philosophy is not necessarily authoritative. A philosophical justification has no authority necessarily. It has to show that it has one by showing how it is superior, it's better than the justifications that may be offered by comprehensive doctrine. So this is in way of indicating the important difference between a conception of the good, a notion that already was there in a theory of justice, and a comprehensive doctrine. That was a clarificatory point. Now I will say something brief in the way of comment. It seems to me that Professor Borowski is very much in agreement with Rawls's account of freedom of conscience. Now here, Rawls doesn't really talk about religious freedom. He was very concerned about it, but he mainly, as Professor Borowski mentioned, talks about freedom of conscience. So I will stick to this language. And so it seems to me that there's very broad agreement. I didn't notice a criticism. Well, yeah, some criticisms, but not in the way in which Rawls conceives of freedom of conscience. But here are my questions. Professor Borowski emphasized very much the priority of liberty that Rawls emphasizes over other goods, in particular over securing the benefits for the least advantaged, and the priority of liberty over restricting inequalities or limiting social and economic inequalities. And that's very true. That was Rawls's view. It's very clear. But within the scheme of liberties, Rawls also draws another distinction between the civil liberties and the political liberties. This is a very familiar distinction, but the distinction that Rawls introduces concerns what he calls the worth of liberty. The worth of liberty is the value that a liberty has for a person. Many of us here care about freedom of expression, but not everyone does in the same way. So this liberty may have different value for different people. And Rawls thought that within the scheme of liberties, the state or a just society had to secure the equal worth of liberty of the political liberties only, but not the civil liberties, not freedom of conscience. So this means that in a way, well, not in a way, that for Rawls, maintaining the equal value of the political liberties was more important than civil liberties in order to maintain a functioning democracy. So what does that mean? It means that we all have political liberties, but Rawls thought that the state or a just society had to provide the resources so that people were on an equal footing when exercising their political liberties. The right to vote. That meant, he said at some point, that perhaps the public funding of elections had to be in place so that people could enjoy an equal value of the political liberties. But he didn't defend that for civil liberties. So according to Rawls, the state had no business providing people with resources for people to exercise their freedom of conscience. The state had no business doing that. That was left for individuals to solve. So that means that within the scheme of liberties, Rawls maintained that the state had probably the obligation to give public funds for the exercise, the political liberties, and that citizens could be on a footing in order to end the inequalities introduced by money in elections, for instance. But the state had no business in doing something similar in the domain of civil liberties. And this is very important in Mexico now, where some religious associations are demanding resources from government in order to exercise what they claim is their religious liberty, a basic liberty. In the Rawlsian framework, the state had no business doing this. And something that is in the background, something that is in the background here for Rawls is that although at the level of institutions, although it's not very clear always, is that he's assuming as a good North American that the exercise of freedom of conscience, and in particular of religious liberty, requires a separation between church and state. He was of that view. This doesn't appear in the basic principles of justice because it's not a matter of the more abstract principles of justice, it's a matter of institutions. But as a good American, he very much thought that liberalism required a strong separation between church and state. So according to this separation, then, the state had to leave individuals alone in funding associations, and in particular religious associations, and the state had no business funding those associations. That was left for individuals to do. And the last thing I'm going to say is that this relates to what Mariana was reminding us about the exclusivist and inclusivist views on the place of religious arguments in public debate, which when Rawls first developed this view in the essay on public reason, he thought it was no infringement on religious freedom to require people not to frame their arguments in the public arena in religious terms. He thought there was no problem with that. It was no infringement of religious freedom. No. So when, for example, legislators were to be required not to express their own views in religious terms, Rawls assumed this was no infringement of the freedom of religious expression. I'm bringing this up because it's important in Mexico now, and some people are claiming that some restrictions that the laicist state, the Estado laico, places on public servants on not expressing their own religious views. Some people think this is an infringement on their own freedom of religious expression. This is not the case within the Rawlsian framework at all. So this has to do with this same point, that the state has no business making sure that the worth of religious liberty is equal for all citizens. It may be very unequal, and there's no problem with that. So my question here to Professor Borowski is how he relates to these views, whether he agrees with the implicit view in Rawls's account that the exercise of religious freedom requires a strong separation between church and state, whether he thinks that it is compatible with the Rawlsian account of freedom of conscience, that the state may provide funding for religious associations. Rawls thought there was no reason for that. There are some passages in political liberalism where he explicitly denies that. So that's whether Professor Borowski shares this background agreement with Rawls on this point. Well, thank you.
Thank you. Well, let me add some other comments. And I think it has been great that we have been able to hear from different perspectives. So the sociological, the political philosophy, the legal philosophy as well. And let me start with one minor clarificatory point on the house that Jack built. It's a book review. It's not the movie you have in mind. There's a terror movie, so that's not the one. The thing is that John Rawls, you can call Jacks to those named John, he liked very much baseball. And as you know, the house that Baby Ruth built. So that was the parangon here. And so that's a minor clarificatory point, nothing to do with your representation. And I think in your paper you mentioned something that is very important from my point of view of Rawlsian theory, which is the veil of ignorance. And I think and you mentioned that on the paper, but I'm not sure if you would like to say something else on the importance of getting the veil of ignorance into the play of the different basic liberties and the rights and how they interact and so on. So that's one thing. I especially enjoyed the part of the paper in which somehow you mentioned the concretization, which you can also call it specification. So maybe you can say why yes or not in that sense. But anyway, the important thing is that rights tend to be very abstract. And the important part is that that we can derive or make them more concrete. So I agree completely in the sense that from all our abstract rights, we can make some concretizations. And the liberty of conscience and freedom of thought, they are still very abstract. And from them, you can actually take the freedom of religion, the exercise of religion, the anti-establishment clause, and that's the specifications or the concretizations of the more broadly liberty of conscience or freedom of thought. So I agree on and I enjoy that part, but probably the question will be on these pros and cons of even going into specification, or which implications do you like of the idea of a specification. But I completely agree that the process of abstract and concrete is something that we have to pay much more attention. And I think the paper does a little bit on understanding this, as also Faviola reminded or mentioned. I am intrigued, and somehow I agree with you, but somehow I'm intrigued. I read Rawls in a different way. On the absolute priority, I tend to think it more in a relative sense. I completely understand that, as you said, that at the end he gives the lexical priority to liberty, which is kind of already giving some extra word or extra weight to the idea of liberty. And in that sense, I don't want to say that that's completely an absolute priority, but I see that he is giving the priority to liberty. But in some sense, it seems to me that that's the same thing that Alexei does with the weight formula. He might go for liberty or he may go for other right, but here Rawls is very specific in going for liberty. But still, I think I have the feeling that we have to take into account that two principles and take the second one in the sense that it's not an absolute priority for liberty always, because it will be depending on whether you get the difference principle, the two conditions met. That will justify a case in which the absolute liberty or liberty will not have that absolute priority. If you cannot give the restrictions or compete with the conditions, then it will not be justified. So in that sense, I have the feeling that he is not making an absolute priority. I have the feeling that it's completely prima facie, and in that sense, I think I agree with your conclusion, but I read Rawls as already doing that. But that's something that we can discuss. And actually, I'm very interested in hearing a little more on the way in which, and this goes to Mariana's points, which also Faviola emphasized, on the inclusive and exclusive debate, and the limits of how much the state can go into pushing some religion or not. So this goes into the discussion of the neutrality of the state and how much passive or active that neutrality has to be. And let me just point quickly to one case here in Mexico, which was very funny in some sense. One of the very few cases in which the Supreme Court has to make announcements on freedom of religion was a case in which there was a divorce. And on the custody rights, one of the parents was Jew, and the other parent, who used to be like a Catholic, had become more like a secular person, atheist or whatever. And at the end, the judge in the first level ruled in favor of giving the custody rights to the mom, but also giving the rights to visit and so on to the father. But he gave the days for the Catholic calendar, so it had all the Catholic weekends or celebrations, which for a Jew father wasn't very good. He was not interested in getting the Sundays, he was interested in getting the Saturdays instead. So in that sense, the case went all the way up to the Supreme Court and the Mexican Supreme Court. And the Mexican Supreme Court reversed the ruling, saying that it's not that you have to be completely neutral, because in some way you are reinforcing one of the versions of the on a country like Mexico with a Catholic prevalence. So you are reinforcing the Catholic faith in that sense, and so that the state will have to take into account this, so have to become a little more neutral, but have a little active part. But I agree with Faviola, without going into a complete sponsoring or endorsing of one church at the expense of the others, or as Rawls said, no church at all. And I think that's the way to go. But anyway, those are some of my remarks, and we'd like to hear from you. And then we'll open the floor to the public. Take one of the mics, because
Yeah. Okay. Thank you very much. This was actually a barrage of remarks, and I'm pretty sure that we will not have enough time to discover everything that deserves to be discussed here. And with an eye to the number and length, I will just proceed chronologically. Thank you very much, Dr. Molina, for the issue of exclusionism, inclusionism. It's an issue that came later, a couple of points. You say religious arguments must not count. This is exclusionism. And inclusionism is that religious arguments are relevant. Now, I'm kind of approaching this a bit from the point of view of discourse theory. And according to discourse theory, there is a universality of addressees and authors of the law. And law is the enterprise, actually, at the end of the day, of exerting force if someone does not comply with the law. So at the end of actually our process of argumentation in the discourse, force is lurking. And now the question is, from the point of view of discourse theory, can we really expect someone to accept arguments on the basis of a religious or philosophical foundation that he or she does not share? Do we expect them to accept these arguments with the result that at the end of the day, that the law, that is the result of the whole process and debate, then at the end of the day may exert force on that person? And this is something I found difficult, let me put it this way. And this, to me, seems to me to point to the exclusion, if at the end of the day, force is the result of the discourse. Alejandro, I agree so much that I have hardly any meaningful remark. Yeah, thank you, Faviola Rivera, for the clarification on the distinction actually between the conception of the good and the comprehensive doctrine. I've found this actually quite helpful and instructive and necessary. So comprehensive doctrine, the characterization of a comprehensive doctrine is then more demanding, isn't it? It's more demanding, and it, so to speak, contains more information, because it, so to speak, has to contain the information how it relates to other competing versions. Yes. With an eye to freedom of conscience, you pointed out that that Rawls gave up religion quite early, and you emphasized a couple of times that Rawls was rather skeptical. And this is also the answer why freedom of religion in his system is an instance of freedom of conscience, which is actually quite surprising, because you would say from the doctrine of constitutional and human rights, at least as far as I know it, it would be rather the other way around. Freedom of conscience appears more as a kind of specifically liberty that is usually understood to be an instance of religious liberty anyway. So this is definitely something that objectively is interesting. And you emphasize the distinction between civil liberties and political liberties, rightly so, and emphasize that Rawls makes the distinction here that political liberty, the pursuit and actually the enhancement of political liberties is something that deserve public funds, while civil liberties not. Yeah. I agree. Now, of course, you may say this is probably the general impetus, so to speak, and there's some truth to it. You could say that I made a somewhat strategic use of Rawls, so to speak, that I used Rawls, looked at Rawls, what, so to speak, is confirming by pre-understanding from a German constitutional law perspective, but, so to speak, then left important aspects and categories out, which you kindly supplemented here too, which I think is perfectly correct. Well, with a distinction between political liberties and civil liberties, because my emphasis was freedom of religion, was my starting point to deal with Rawls, of course I paid not much attention to political liberties. And so this is something I simply did not explore. This is, so to speak, a result, an unavoidable result to some, we might say, from my approach to Rawls as a subject. However, although he makes the distinction, if we look at the list of basic liberties, we find liberty of conscience as a civil liberty and the political liberties both in the list of basic liberties. So this distinction you correctly emphasize here is not reflected in the technical characterization in terms of importance in Rawls systems. And this was, so to speak, the only point from which I was coming. Now, and of course, the culminating point here is what about public funds and religion? Now, you have to be brave now. In Germany, we have the church tax.
I know.
The church tax. Well, the church tax is not actually a subsidy of the state, but the state assists the churches who are registered as, you have to, again to be brave, as public bodies, in Germany, Körperschaft des öffentlichen Rechts, registered as public bodies, they actually can levy taxes. The taxes then are paid by those who are members of the church, but they don't have to send a check to the church, but the state collects this through the normal means of collecting taxes. So this would be, I think, north of the border would be the internal, the IRS, and we all know, don't mess with the tax man. This is probably in Mexico as true as it is. Oh, I don't know. As true as in Germany and the US. So it's a very effective way of collecting taxes, and it is set at a specific height. Now, is this a problem? It would be a problem, of course. Well, it is not a state subsidy, but it is an enormous help for the churches, because you just declare that you're a member of this or that church, you're Catholic or Protestant of that type or that type, and then the money will be collected from your salary basically every month and is automatically transferred to your church. And the risk of insolvency, you running off for a different country, not paying your church membership fee is, so to speak, completely gone. And so this is not in terms of money, but in terms of help, of getting the money, it is a significant subsidy. This would be a serious problem if this were a privilege only for one church or a certain group of big or traditional churches. Actually, it is not. I can assure you that in Germany, nearly every religious association has access to that status if this association applies for it. And there are examples of smaller associations who have actually that status. There is a problem with religions who do not have a firmly established structure. And so this is for Muslim congregations, this is a bit of a problem because they usually do not have this institutionalized structure that you would require to have a legal person in a legal system. This is a bit of problem on that side, and there's also a famous decision regarding the question whether the religion has, on the whole, to obey the law. And there are some associations who are in, so to speak, constant battle with secular authorities. For example, the Jehovah's Witnesses, who refuse some legal obligations. And then the question was raised whether actually, if you can be part of the state, if you are against the state. And this was resolved in a manner, I would say, which is fairly tolerant. And it was ruled that actually it has to be serious and repeated violations of core legal provisions that would rule that out, but not some kind of, so to speak, normal ideological problems. At the end of the day, look, if you have a kind of compromise solution on the eternal problem of abortion, and then you have a devout Catholic who says, from a basis of protection of life, actually I criticize this rule. You wouldn't say, well, the Catholics are not obedient to state law. You would expect to some extent that religions criticize, from a religious point of view, current state law. This is perfectly fine. So this is not the problem in and of itself. So do I have a problem with the German system on this equal footing? No. John Rawls would probably have serious problems with that. But this is my answer. Thank you. Imer, the veil of ignorance. You mentioned you want to hear something more from me. I don't know really what else to say. I think the important point that reminds us when we take part in discourses, we always do that kind of knowing our own position. And the veil of ignorance is precisely designed to prevent that.
But taking your example on the religions body funding to public bodies, it's behind the veil of ignorance. I don't know which religion will be getting more money, although we can expect that major religions will be getting, but they will get it in the proportion of their people following them, their believers. But anyway, so I think that's important to keep that in mind, not only in the original position, but also into the design of which policies will pass a certain test.
Yeah, in some sense, the veil of ignorance is somewhat parallel to the idea that if you discuss issues with someone else, it's a kind of abstraction from your own particular position. The rule that you are supposed to try to take the position of your opponent and look at the situation comprehensively from your opponent's point of view. In some sense, there's a kind of relation between these rules, and I think this is a good idea to to come up with a result that is as fair as possible to everyone, and not a maximization of a certain, the individual own position. Okay. The concretization issue, yes. Rawls is, as far as I remember, I have to say, we have you here present, Rawls is not fairly specific on concretization. I think this is not very clearly developed in his theory. Of course, with all sorts of concretizations, the problem is you have to take normative decisions in concretization, because there are different ways of concretizing, and the compromise, the concretization may actually be more realization of one of the competing principles than the other, or the other way around. So decisions are being taken in concretizing things, and the question is, how do we deal with that problem? We can deal with the problem by coming up with substantive rules, but where do they come from again then? We can come up with something like a structure that is proportionality, but the proportionality as a structure cannot decide issues. You need to justify the balancing decision again. So this justification issue is there, and it doesn't go away by just putting structures or lists in here. Interestingly, the absolute priority of liberty over redistribution of wealth. First principle is just over the second. I read Rawls, and I think he says, he specifically speaks of a lexical
Priority.
order.
Yes.
And I think this rules out that there is something more soft going on. But of course, I will think about this, because it would I would love to have a deeper understanding.
Let me add something.
Yeah.
Why putting two conditions if only the first one is the one who makes the show? So it's the lexical priority, I completely see, but then there's the second one. And the second one is justified as long as it more or less helps and is compatible with the lexical priority. So it's not an absolute priority of the liberty. It's as long as you can justify your second one, making it available to all, and specifically to all those less advantaged members of society, then your number one might be compatible, or you might make the two compatible. So that's what I take on that. And in that sense, I think your conclusion is very similar to what I think that's my reading of Rawls, but I might be wrong. I might be reading it very, very strangely, but I think that's the way to understand that there were the two conditions, and the first one has priority, but the second can be justified if met somehow the first priority. So in that sense, it's not that it's completely overriding the first one, but it's making a move that is compatible with the first. So that's the way I think in making it, and for me that makes that sound not an absolute priority but a relative one.
Interesting, and I would love actually to develop this a bit further. But I have to say, it was not the focus of my attention, because I was not dealing with the difference principle at all. I hardly mentioned it, but thank you. Interesting point. Yeah. Okay. Yeah, but I think now the audience has listened so patiently to our exchanges.
Yes, and then many hands raised already. So, Itzel, Edgardo, ¿tu nombre? Daniel. Les pido si se pueden presentar y Itzel, te pasan el micrófono.
Thank you very much for your talk. I'm Itzel Mayans from Instituto Mora. I'm a teacher there. And I have a couple of questions of clarification as well. The first one is, what would be the substantial difference between balancing and regulation from your perspective? Because I find it very related somehow. I mean, maybe it is true that Rawls doesn't refer to balancing, but I think that regulation could be a way of balancing rights in conflict. For instance, there's a footnote in political liberalism, in which Rawls addresses the issue of abortion. And he says that the freedom of women to decide whether to interrupt or not her pregnancy conflicts with the value of a progressive evolution of life, and then conflicts as well with the legitimate preoccupation of the state to regulate the reproduction of society. So all these are political values that conflict among each other. So there's, and he says that only the solutions that does not take account one of these values are against public reason. So this is a good example of Rawls saying that there's a way of balancing rights in the sense that everyone can get, has to be taken in consideration in a decision, in a political decision, and it's what Supreme Court, as far as I know, also does. So I was wondering, what do you have in mind, and what would be the difference between these two concepts that you use? The second issue is, I didn't get exactly what do you think that it counts as a violation of freedom of religion. And because when I heard Mariana's and Faviola's comments, I was deciding, or I having doubts whether you thought that it was something that occurs in the background culture where citizens can inflict or interfere with one another in the protection, in the violation of the rights of freedom of religion, or can interfere in the conception of the good that everyone have, or if it was something that was a negligence from the state, in the sense that the state was not protecting correctly the legal rights to have the exercise of religion freely, and it was more a matter of negligence or bias that the state was not really complying. So it would be helpful if you could give more specific details of what would you consider a violation of this important freedom.
Should you answer this one, or we take several questions?
I would actually like to answer this because my memory is not as good as it should be. Could say was, but maybe this is not even correct. Okay. Substantial difference, balancing or regulation. As if I read Rawls correctly, his characterization of a regulation is, for a lawful regulation, is that it respects the central range of application. This is what he says. It respects the central range of application. Now, what I hear with my German ear and the German brain connected to the German ear is Article 19, Paragraph 2, Wesensgehaltstheorie, the theory of the essence of a constitutional right. And the theory of the essence of the constitutional right, it is actually somewhat contested what this means, but it means, according to the currently prevailing view, proportionality. The core, and the core is established, the core of the right is the area of the right in which this right outweighs all other competing rights and goods. So I would see no substantial difference. Having said that, I would see no substantial difference, and I reckon that Rawls, when he talks about the central range of application, has something like that in mind. And my criticism in the second part of my paper was not that Rawls does not balance, but that he limits the instances in which he balances too much. This would be my impetus. I wouldn't say, well, he has the basic liberties, and they can compete with each other. So balancing has to go on there, but he rules out some other constitutional essentials, technically, that are not basic liberties in his view, which in the constitutional doctrine of Germany, there's no problem at all in balancing a constitutional right against a collective good, like environmental protection. So that something is a collective good does not mean that something is not important. So these kind of firewalls that there are or that I see, and that I may not see any longer once I have followed your lines of argument, these firewalls is something we have torn down in German constitutional law basically completely, and now do everything with balancing and this relative priority that I've tried to outline. With the violation of freedom of religion, well, I can't claim to be specifically Rawlsian here. I don't think that Rawls offers examples because it doesn't speak too much about religion, right? No. Well, religion, the freedom of religion, so to speak, turning now to the German constitutional doctrine mode, is a constitutional right, and it is primarily there to prevent a violation by the state. You need interference with that right. And what can this interference be? This interference can, for example, be the famous crucifix decision more than 25 years ago now, echoed by the Lauzi decision of the European Court of Human Rights in Strasbourg, Grand Chamber decision in Italy, same problem. Public school, and there's an obligation of children at a certain age to attend school, so they have to be there. It's actually unlawful not to be there. And in Germany, homeschooling isn't an option. Mm-hmm. And this is another discussion one can have. But then there was in Bavaria a particularly, well, when I spoke about religious diversity, it attends not so much to Bavaria, because Bavaria is predominantly Catholic. They have the Franconia, who are Protestants, of course, but they are by proper Bavarians not to be considered Bavarians, or they take care of. Well, be that as it may, a rather Catholic state. And there was a legal regulation that it was a legal obligation that in every classroom there is a crucifix that has to be clearly visible, not behind the blackboard or something like tricks like that, but has to be there, very visible. And now, well, it's not the worst thing that can happen in life. Yeah, if we talk about torture and ethnic cleansing and so on, these things sound rather as luxury problems. But they are problems because they are connected with the problem of identity. And there were parents, children and parents who were opposing that, and to be exposed to the view of a specifically religious symbol in a secular sphere was actually considered to be a violation of religious freedom by the Federal Constitutional Court. There was a storm going on, because then the newspaper said, well, the Constitutional Court has actually ruled the crucifix unconstitutional, which is a bit broad as a claim, because it was only about this specific situation only. There was a decision 25 or 30 years earlier in which actually a big crucifix was present in a courtroom, a Christian crucifix, and a Jewish lawyer, practicing lawyer, who had to represent a client, opposed that. And the court said, no, we are in Germany, it's the Occident, this crucifix remains here. And the Constitutional Court ruled at the end of the day that this crucifix in the courtroom was unconstitutional. And no one objected to that at all. So there was clear agreement that this is impossible. With the crucifix thing, it was a much more complicated issue. And this raises the interesting question, I don't know whether we have time for that now, but it raises the question what actually is a religious symbol and what a religious symbol means. And there were very interesting statements made in the context. Some people said, well, look, the crucifix is there at the wall. And now what this crucifix means depends on the context. Now, if there is religious instruction in Germany, then this crucifix has a specific religious meaning, which is of course harmless, because only those attending this religious class who share this religious belief. But now, once religion is over and biology is at stake, the cross is still there, but it automatically changes its meaning, and it's just a secular symbol for the historical roots of Germany, which is very convenient, of course, if you want to keep it there. And but the symbols are, of course, I think there are many US cases on religious symbols, and I think in other. So this would be an example of a violation. Also, you could also argue, although this is not clear in many cases, but in some it is, there is also the obligation of the state to protection. Because you can be a member of a religious group, and this religious group denies you the right to exit the group. Strictly speaking, as far as I am familiar with the Christian theology, having been baptized is indeletable. So from the point of view of religious, Christian doctrine, if you have been baptized, this cannot be undone. To remain baptized, even against your will, you have no choice. But of course, usually in the liberal democracies, you can exit Christian beliefs. But it is actually, the state has to guarantee that you can exit a religious group and stay unharmed afterwards, and that you are not subject to pressure and suppression and so on by your former fellow believers. And this is, I think, this is quite an important aspect. And we can, so to speak, tolerate that religions are not particularly democratic. They don't have to be, because their revelation may say something different, but this is not that problematic as long as you can always leave if you want to, and that this is effectively protected by the state, even against your own former group.
So Alejandro is going to heaven even though he's making everything possible not to? Edgardo.
Well, regarding the exclusiveness and inclusiveness debate, there were certain critics to Rawls' public use of reason, in the sense that this idea of him lays an extra burden on the shoulders of the religious citizens regarding the secular citizens, because when you require them to translate the religious reasons or arguments into a secular language, there is like an unequal treatment from the state towards the religious citizens. So this will signify an extra burden on the shoulders of the religious citizens regarding the secular citizens. That's why, for example, German philosopher Jürgen Habermas, discussing with Rawls, makes a separation between the formal public sphere and the informal public sphere. And contrary to what Rawls said, Habermas arguments that there is no problem when you use religious arguments or reasons in the informal public sphere. There is a problem when you use them in the formal public sphere, the institutional level, no? And he arguments that this doesn't mean to be when you require religious citizens to translate their religious reasons into a secular language in the formal public sphere, doesn't mean an extra burden on the religious citizens, because the liberal regime or liberal democratic regime also oblige secular citizens to be open-minded towards religious reasons and to contribute in the translation of the religious reasons. So, what I mean, in my point of view, if we want to create a real pluralistic democracy, we should allow religious citizens to participate with their religion's arguments in the democratic process, even in the institutional level. So I think that we should exclude religious arguments from the formal public sphere, but not because of their religious form or their religious language, but because of their secular content, when they are contrary to human dignity and human rights. So I think I think that if we want to create a pluralistic democracy, religious arguments should participate in the process, but obviously with this filter that when they are contrary to human dignity and human rights, we should exclude them. But in that point, I don't agree with Rawls also when he requires religious reasons to be translated into a secular language. I even think there is not like a public use of reason and a private use of reason. I think there's only one reason and there's only one use of it also. Thank you.
You want to take this one or we can take another one?
Do you want to say something?
No, you go ahead, please.
Yeah, if I... memory. Well, thank you. To some extent, you seem to assume that you can translate a religious argument into a secular argument, and that is, this is now a question, that this is still the same argument. I'm not sure that this is true. What do you make of the argument, God told me so? Exactly. So it's gone. And so the undue burden is not that it is difficult and painful to translate it. The consequence, if we exclude religious arguments from the debate, if they cannot be translated into secular arguments, is that they are excluded. This is okay. I'm not, so to speak, on the top of my head aware of this Habermas-Rawls distinction. Could you give an argument? Could you give an example? What would be an informal public space, and what would be a formal public space?
Well, for Habermas, the formal public sphere is the place or the space where, like, I don't know how to say it, like decisions that are obligatory for the rest of society are taken. Okay. So it's like a parliament debate or a court or yes, okay. And the informal public sphere is like the public opinion. So for Habermas, religious has a place in the construction of the public opinion, but if public reasons want to also participate in the formal public sphere, in a parliament deliberation, for example, these religious reasons have to be translated into a secular language, and secular citizens have to help in the translation of these religious arguments. Mm-hmm. I think I also don't agree with Habermas in the difference that he makes, because I think it's really difficult to make this separation between the informal and formal public sphere.
But this distinction, just let me, is roughly Rawls's distinction, roughly, between background culture, which would be like the informal public sphere, and what he calls public reason. Yeah. Because he says Rawls' public reason is the reason of officials, officials serving in the Supreme Court, legislators. Well, he also says citizens when debating their vote in elections. But that's a very contentious and specific. It's mainly the reason, public reason, the reason of officials, mainly. Yeah, that's roughly the similar distinction.
I intuitively strongly agree that genuine religious arguments have no place in formal public sphere, because actually a judge who, instead of presenting a legal argument why I am being convicted of a certain crime, just says, God told me so, is something I can hardly imagine. It becomes a bit more difficult when we talk about legislation and democracy, because genuine religious arguments can have genuine democratic value in the sense that members of parliament represent, in making this argument, actually precisely their voters. But I have to think about how to deal with this role that one might give it to that. Okay, thank you. Thank you for that.
¿Recuerdas su nombre y de dónde vienes?
Mi nombre es Daniel y estoy considerando hacer mi doctorado en el Instituto, así es que soy externo todavía. I'm sorry, I'm going to shift to English. My name is Daniel. I'm thinking of doing my PhD here, so I'm an external so far. I do agree with Rawls when saying that liberty should have a priority over equality or distribution of wealth or any other social interest. It seems that all modern states, all constitutional modern states do start from that principle that persons should have liberties, that states should not trespass, and that provides a safe environment for people to develop and to build their own life. I think that idea is particularly difficult for a country like Mexico that has a tradition of a social interest principle. We like to since our constitution, our 1917 constitution, has some of the first social rights, what we call social rights, the rights of workers, the rights of farmers, and we placed rights, constitutional rights, on categories of persons: workers, farmers, natives, all sorts of minorities. That category, not the persons or the people behind that category, but the category itself has rights, like has constitutional rights. And we like to think of those rights of a social interest nature, what we call social interest. So my question is really how would it work for Rawls, or maybe from the view of a German constitutional analysis, a balancing between a liberty and these kinds of social groups, rights, socially created, not in the sense of a liberty that that comes from the person, but that us as a society or a group or part of society decided to place a right there. Because it is easy for me to think of a balancing between two liberties, like liberty of conscience and the liberty of life. And I think there's a classroom example of a family that is of a certain religion that prohibits blood transfers, and so there's these balances between liberty of conscience and the life of the person that needs the transfer. So that's easy for me to understand, but it's a little bit more difficult to think of a balancing between liberties and these social interest rights. And you've mentioned collective goods, and so what I can see, it's something that it's been done like on a normal basis on constitutional analysis in Germany, but I wish you could explain a little bit more about how that works.
Yeah, thank you. Insofar as social rights, that is specific constitutional provisions that requiring the legislator to basically redistribute wealth. One can place them. Now, the question is balancing possible between liberties and these social rights? And this depends actually on how the story goes on with the absolute priority of the first principle, liberty, over the second. In the paper, this wasn't the focus of my attention here when I outlined these things. In the paper, I refer to what I saw as a kind of incoherency that in Rawls' later Law of the Peoples, he finds as a human right, a special class of urgent rights. He includes the right to subsistence, including minimal economic security. This is not among his basic liberties, of course, in the first theory, but it now shows up in the list of human rights, and this is not a basic liberty, but there are basic liberties in the first part who do not show up as human rights. So either I haven't understood Rawls correctly, this is what we need to investigate on that front, or he changed his mind. Of course, you can, from a German point of view, there's little help there because the German Basic Law of 1949 does not have any explicit social right. Not because the Constituent Assembly didn't want social rights. The problem was that social rights were regarded in the earlier constitution, the Weimar Constitution, they were considered to be a very problematic class of constitutional rights because no one could really figure out the extent to which they were binding on the legislature. And so this was a kind of danger for the whole project of constitutional rights. And after World War II, after the catastrophe of the National Socialists in Germany, the framers said, well, we want to have now clear and strictly binding constitutional rights on the legislature, all branches of government, and we didn't want this to be weakened by this difficult case. So we leave that for the future to figure out. And there has not been any reform yet. There is an unwritten social right in that sense. This is the right to the minimum subsistence level along the lines of what Rawls here, I think, means. And this is brought about by an interpretation of human dignity. And so to speak, the content of human dignity is that you are not dying from hunger in our country. But this is only the limit. What you refer to is something different, and you mentioned that specific minorities are mentioned, and that specific rights, economic rights, or kind of structures that help them economically, are given to these specific groups. Now, you can do that if you come to an agreement at the constitutional level to do so. The problem, of course, that then comes up is that the groups to which these rights are afforded may prove to be under-inclusive or over-inclusive. Once you begin to give specific rights, specific groups specific rights, this is potentially the starting point of, metaphorically speaking, an equality mess. Because then you realize that there are other groups who have the same claim, if not better, but they are not specifically mentioned. Then you begin to argue that the Constitution needs to be changed by means of amendment, which may be difficult, or by means of interpretation by the Constitutional Court. So you can do that, but it's a dangerous business. I would say. And I think still we don't have a good answer on the binding force that these social rights have for the legislator. There's an easy way out. I could say, well, this is also done by proportionality. And I think this is correct, but it's terribly pale. And we are still very much in discussion as to whether and how you can actually apply proportionality to positive rights, because the structure is different. There are problems lurking. We are working on that, but it has not been done yet.
Can I say something quickly? I know we are almost over time, but just two quick examples that matter to Rawls to illustrate this point. Suppose a government were to say that for the sake of political stability, there's the need to establish an official religion, say. It's the religion of the majority, and so for political stability, it is better to establish it or recognize it as the official religion, although it's not everyone shares this religion. So in this example, you are subordinating freedom of conscience, you are trampling freedom of conscience for the sake of a collective good, which is stability. And then another example that mattered greatly to Rawls, and that it's very important in the theory of justice, is when you suppress political liberties, which are liberties, are included in the scheme of basic liberties, when you suppress political liberties for the sake of economic development. That has to be very familiar to us in Mexico from the 80s, when the so-called political reform was postponed once and again, and so the government did not respect freedom of political expression, not even freedom of political association, equality of participation in political processes. All these are political liberties that were suppressed and subordinated to the collective end, allegedly, of economic development. So this doesn't speak directly to the point on social rights in specific, but that's the kind of trading of liberty for the sake of a collective good that Rawls meant to oppose by establishing the priority of liberty.
That reminded me of something I wanted to say, actually, but very quickly. You took for granted that one would never sacrifice liberty for economic redistribution. I think we currently see around the globe authoritarian regimes being quite successful. And authoritarian regimes refuse liberties to the population, but promise economic growth.
Right.
And I think we see that people are willing to make this compromise, which I don't know. You can use this as the basis for different arguments, but in practice we see that people are willing to some extent to make these trade-offs. Yeah.
Buenísimo. Si les pido que se unan a mí en un agradecimiento. And thanks to Martin for...
Great.
Thank you.
Thank you.
It was fun.
Thank you.
Vamos a pedir mi pastel arriba en la terraza hace más tiempo.
Oye, no sabía que hubiera tanto mucho.
The last
Qué buena
part
forma de
reminds me of the
celebrarlo.
paper of Hart.
Tú sabes que soy...
You know, the picture